I'm Lindsay Altamirano, estate planning attorney with Alta Legacy Law, and we're going to talk about titling real estate in California. Always California laws for my videos. So typically when you buy a house or you refinance a home, that escrow officer is going to ask you how you want to title your real estate. They're probably not going to tell you how to do it because technically that's legal advice. There are a lot of ramifications and consequences for how you title your real estate. So we're going to go over some common ways. Those common ways are joint tenants, tenants in common, community property with right of survivorship, and other entities like a trust, LLC, or the like. One way is joint tenancy. So 2 or more individuals can hold title to real estate as joint tenants. Basically, that means you all have 100% interest in the real estate, and when one of you passes away, the surviving individual or individuals can all immediately take your interest instead of having to go through probate to get your interest. So it's a pretty common way for people to hold title. Another way people hold title is as tenants in common. So again, 2 or more individuals can hold title as tenants in common. And in fact, tenants in common is another way to hold title with a trust, which we'll get to. But the difference between a tenant in common and a joint tenant is that when someone holds title as a tenant in common and they pass away, their interest goes through to either their heirs through probate, or if they have a trust holding as tenant in common with other people, then it goes through their trust. So again, instead of joint tenancy where everything goes to the other individuals that are holding title to the real estate, a tenant in common goes through to their heirs. And the shares can be divvied up however you like, 50-50, 50-25-25, but those percentages need to be specified on the deed. Another way to hold title is as community property with rights of survivorship. As you might imagine by the wording, this is reserved for married individuals and only applies in states with community property laws, and California is one of those few states. So married individuals will often hold title as community property with right of survivorship. Some married individuals will hold it as joint tenants. However, due to our laws, that might not make as much of a difference as you think, because it could just be considered community property regardless. There are also different tax benefits to holding it as community property with right of survivorship versus just as a joint tenant. But that you want to check with your CPA or any tax accountant that you work with. Another way to hold title to real estate in California is through a trust. One of the many reasons that people create trusts, and probably one of the most common, is to avoid probate, which you might have heard before. A lot of people talk about avoiding probate in California. Well, certainly if you have real estate, just due to the value, without a trust, that real estate will go through the probate process. So creating a trust and ensuring that the trust is on the deed as the title holder will help avoid that process. Another way people hold title to real estate is with an LLC or other corporate entity. In fact, a lot of individuals who own rental properties will put the rental property into the LLC, which means the LLC is the one holding title on the deed. And then they'll create a trust, and the trust will be the LLC member or the shareholder in the corporation. And that ensures that all of the real estate in the LLC will be able to be managed through a trust and again avoid probate. I hope this video has been helpful. If you'd like to learn more, please look us up online at www.altalegacylaw.com. If you have questions about your specific situation and would like to schedule a complimentary consultation, please call us at 424-242-5021. We offer phone call or Zoom video call for all of our services to make it more convenient for you.